Alex here with part 198 of the My Docket series on child custody and visitation. As my previous videos, I'll take this opportunity to direct my viewers to part 0 if you haven't seen it yet. That's the video that comes up with all the detailed disclaimers and the underlying purpose of the series. Two things that I glaze over are: number one, I'm not in the middle of this right now. My case is completely and totally over. It's closed. It cannot be reopened. And that's because my ex's parental rights have been terminated. Number two, the nutshell version as to the purpose of the series is to give my viewers one big example of my 8-year-long high conflict child custody ordeal from beginning to end in chronological order. We now go into the court's order regarding my renewed motion for contempt. If I remember correctly, I get everything that I wanted that was raised in that supplement. The basically what was the, I don't want to say backdoor, I guess you could say the side door, to let the court resolve all of those issues without being forced to set a hearing. And I remember feeling good about it because, number one, for once, the court listened to a suggestion that I had. And the reason I say that is because I had filed a number of proposed orders to this particular judge, and she just wouldn't sign them. Other judges in other departments would sign my proposed orders. This judge just wouldn't do it. And even though I don't think she signed my proposed order in this case, it was nice to see that I could at least give her some suggestions in a supplement that she would abide by. So I felt really good. My mindset was very positive, and I felt like I was able to save everybody a ton of time. And I ended up getting the order that I wanted to get. So I think this is going to be a shorter video because there's only going to be that one document that we cover. And that being said, let's go ahead and take a look at what the judge has filed. Here we have the order regarding renewed motion for order to show cause or for the alternative relief requested. Standard introductory paragraph, she indicates she's reviewed all the papers and orders associated with my renewed motion for order to show cause. She now finds and orders as follows. Okay, so these are not findings of fact, guys. Just disregard this. This is a procedural history. The first is that we are parents of a minor child. We share joint legal custody of the minor child. I enjoy primary physical custody, specified to my ex's visitation rights. She pays a certain amount of child support, subject to wage garnishment. On January 20th, the court entered order denying my motion for order to show cause and directed me to renew it with an appropriate affidavit. I renewed my motion. I attached a fact-specific affidavit. I allege that my ex is required to make child support payments, that I have outlined my attempts to communicate with her regarding the child support, that I have outstanding child support arrears in the amount of $2,654, that she was ordered to pay me child support arrearages in the amount of $29.98.43, and that she has failed to make payments on the arrearages in over a year. Shocker. This is why I don't feel bad that she got overturned on appeal twice over this stupid issue. And then we have the refusal to exchange the clothing during exchanges. Okay. On February 18th, I filed my supplemental proposal for expedient resolution, stating various means of resolution to obviate the need for a hearing. My request is to relieve my ex of her duty to provide the child with medical, vision, dental benefits. To request that the court order that prospectively monthly payment plan as referenced in previous orders vacated in its entirety, and that the district attorney can proceed to execute on satisfying the outstanding arrearages, and that I am no longer required to exchange clothing at exchanges, and I'll give her a $25 deviation in child support. Okay, and then there's the allegation that she's not used Family Wizard in over a month. Conclusions of law. So she takes DCR 13 again and uses my ex's failure to file an opposition against her and treats that as an admission that what I am asking for is meritorious and should be granted. And then she cites the law defining contempt as disobedience or resistance to any lawful writ. We have already seen these statutes raised a bunch of times in this case. Based on my supplemental proposal for expedient resolution and the court's determination, a hearing is not warranted. Good. As there is a separate case enforcing child support involving the district attorney's office, I shall proceed with my claims regarding her failure to pay child support in that action. Because the parties' complete inability to cooperate to meet the reasonable needs of the child, to remove one element of conflict, neither party shall be required to supply clothing. Yay! I am suggesting a reduction in child support to $25 a month to allow her to get clothing. It is so ordered. Child support shall be amended to $446.51 plus one half the cost of healthcare premiums. The parties are reminded that our child's things are his and that he may take his things with him from place to place. The court affirms and reiterates that parties shall communicate with each other only through our Family Wizards website. Certificate of Rule 5 service, let's see, indicating that this document was mailed to both me and my ex. By the way, guys, I still think that this order shows her incompetence on high conflict child custody. So she says it's the party's complete inability to cooperate to meet the needs of the child. And by doing this, she's expressing her frustration to make it seem like it's both of our faults. And I think a lot of family court judges, I think probably 99% of family court judges, are under the false impression that it takes two to tango. That's just one of those stupid sayings. It's not true. It only takes one to tango. It takes two to agree. So ironically, that statement is completely backwards. It's no different to me than the other nonsensical statement, which is that a person who represents himself is a fool for a client, because that implies there's a choice. Both of those sayings are very popular, and both of them are so wrong, and they lead people down the wrong path. People don't represent themselves because they choose to. People represent themselves because they're not millionaires. And people don't cooperate with their ex, not necessarily because both of them are trying to fight. It only takes one person to fight to create a high conflict case. It doesn't take two people. So this is, again, not just this one judge. I believe that this is an issue that's pervasive throughout the entire family court system. And if you want to know more about why I think so many of these judges have this wrong-headed approach to these cases, watch my video on the topic, high conflict incompetence. I filed a motion for order to show cause. The district court disposed of that motion by granting it. Going into the aftermath, I filed nothing, so I incurred $0 in costs. My ex filed nothing, so she incurred $0 in costs. I didn't have an attorney, so I incurred $0 in attorney fees. My ex didn't have an attorney either, so she incurred $0 in attorney fees as well. As my previous videos, if you have any questions, feel free to post them down in the comments below, and I will see you guys next time.